Thank you, Professor Alexei Trochev. It's for me a great pleasure to be in Astana for my very first time in Kazakhstan. It's a very nice place. I arrived yesterday morning and it's a very good for me to meet your university, this very good university I know, Nazarbayev University, and talking about this issue, rule of law, democracy, and constitutional courts. I'm a full professor of constitutional law and also public international law, and I think we will have a very good dialogue in these issues. I think that will be very good for you because you are from political science, and all of these issues are related with the conception we have now in terms of organizing our constitutional state, because in our times we have a new model of organize our society and the politics that we today we call constitutional state or rule of law, because this is the usual name you used to see in the global with the global features, the state we have and the power we can exercise inside our state and the power of the citizens inside the states. So I will follow my lecture with this PowerPoint, and this is a brief summary of some ideas I would like to reflect about. These 7 points you can see. After the Professor Alexei can give freely to the students this PowerPoint presentation, no problem. And later, if you want to contact me, you can use this email address. That is here. You have my email address, and this is my site. And I'm also connected with social networks like Instagram, Facebook, or LinkedIn. And also Professor Alexei is a very fan of the social network. So I will start to talk about, with this summary, about the rule of law we have indeed in nowadays in our world. That is the contemporary idea of having a constitutional state. You know that this kind of political organization, we started with this kind of organization after the constitutional revolutions, the American Revolution, that was also an independence revolution, and the French Revolution. These two very important moments began a new era of political organization in the modern state. We call the contemporary state or the second modern state that we have since 19th century till now. So we can have that kind of name that usually that is constitutional states because of the constitutional revolutions. But within these two centuries, the 19th century and the 20th century, things obviously change a bit, because in the 19th century we had a liberal state, the first civil and political rights, and the separation between the state and the economy and the society. But after the first and mostly after the Second World War, we experienced a new model of constitutional state we used to call welfare state. Obviously, you know what is a welfare state, and this is a different pattern of organizing the politics and the relationship between the individuals, society, and the power. But now we are perhaps in a new phase of this evolution. We are facing some crises, some challenges because of new problems we are facing now in our world and our states, and we'll talk about it in the last point of my lecture. But what is the meaning of constitutionalism? What is the meaning of having a constitutional state? That's the point I would like to underline now. Because this is not a thing that is obvious, because between these 2 centuries, along these 2 centuries, we had a lot of different revolutions. We have dictatorships. We have other bad experiences, like the colonialism from the European countries in Africa and in the 19th century in America. Portugal also had a bad experience of colonialism, mostly in Africa, and before that in Brazil till the beginning of the 19th century. But if we talk about constitutionalism, that is, we have in mind some features, some things that are binding to have that model of a constitutional state. And we think about those features because those features are very important to have a good state in which we can have a good life and living together in peace, with security and with liberty. That is the aim, the principal aim of having a constitutional state. And in this point 1.5, I would like to summarize perhaps 5 or 6 features of this constitutional state. That is having a written constitutional text, written constitutions, a recognition of fundamental rights, and democracy and separation of powers, control powers from by the judiciary, and the separation between the dimension of politics and dimension of the religion beliefs of persons. We'll see each one one by one just to explain better what is the meaning of these main features of constitutional state. So let us see the first feature, and all these features are included in the general idea of rule of law. We also say rule of law using the expressions we have in French, or perhaps in some other countries, like the état de droit. You can see there état de droit en français, Rechtsstaat in German. So it's some different names, but different names that can summarize the same idea, that is the rule of law, a well-organized constitutional state. Let's go forward, and in this first feature, I would like to talk about the written and rigid constitutions. You know, all the countries now, we have, each country has its own constitution. That is a very important legal text, the highest legal text we have in our legal order. And there we can see mostly 2 things. Fundamental rights, rights from the people against the power, and we also see a second part, that is the organization of the powers, the judicial power, the executive power, and the legislative power. So this is the function of the constitutions, to put in order with the idea of system, legal system, the functioning of the powers of the state, and at the same time recognizing the fundamental rights of the people. It's very important to have this kind of text, because if you don't have this kind of text, we will have a chaos, we will not have a system, and we will not have a certain about the powers and the competencies of the different organs of states. And most will not have enshrined in the highest text our fundamental rights. So now in old countries there is the need to have a written constitution, and more than that, there is the need to have a written and a rigid constitution, not a flexible constitution. What does that mean? That means that the Constitution, because of his highest importance and role, the Constitution must have limits to its revision. We cannot review the Constitution as the same method we can adopt to revoke or modify ordinary law. Constitutional law is in the higher place in the legal order, so we must respect some more limits to the review or revision of the constitutional text, and mostly we have temporal limits. In Portugal, for example, we only can modify our constitution after 5 years after the previous revision of the constitution. That is one of the limits we have. We also have to adopt a qualified majority to approve the modifications to the Constitution. That is a 2/3 majority, the qualified majority, higher than the general majority, that is a relative majority of more votes in favor than against the adoption of some law. And we also have perhaps the longest list of issues, of topics in the Constitution we cannot change. That is a list of 14 topics in the Portuguese Constitution we cannot change. Perhaps it's an exaggerated list, I'm sure about that, but in fact the idea of the constitutional law was to preserve some nuclear aspects of our legal order in order to not to allow in the future the later constitutional power that is enshrined in the first constitutional law, and so further revisions of the Constitution cannot change or suppress some values or some principles we have enshrined in our Constitution just from the beginning. Our Constitution was approved in 1976. At that time, the most of you, or all of you, were not born. Professor Alexei was a very young man at that time, as well as I was. But it is important to preserve the Constitution, the idea of having material limits of some principal topics we cannot change, never in the future power of changing the Constitution. So this is the idea of having a written and a rigid Constitution. Just to be more secure about the fundamental law we have, and the law that is for all the people, without any kind of division, political division or ideological division or social division. So the Constitution of a country is a very important document and law, because the Constitution must be the law of all the citizens, not only for a part or a group of the citizens, but all the citizens. That's a very important conclusion we must have now after these 2 centuries of constitutionalism. I think it's a very unanimous conclusion. Now I would like to draw your attention to the second point. That is perhaps easier to understand, is the idea of having fundamental rights. We also use the expression human rights, but human rights is normally reserved to the public international law. When we are talking constitutional law, you use the expression fundamental rights, not human rights, but they are the same. What is the difference? Fundamental rights, these rights are enshrined in the constitutional texts, in the constitutions, and the human rights, the rights are enshrined in international treaties from the United Nations or from the regional systems of protection of human rights. We have in Europe 2 main systems for the moment: the system of the European Union the Charter of Fundamental Rights of the European Union, and before that we have the important convention, European Convention of Human Rights, approved by the Council of Europe in 1950. So it's the two systems we have in Europe, but we also have a specific system in America, and another one in Africa, the Chart of Human Rights and Rights of the People in Africa. So what is the main aspect I would like to say about fundamental rights? Fundamental rights, we have a list, a very extensive, now a very big list in our constitutions, in your constitution as well, in the Portuguese constitution. I don't know a constitution in the world without any catalogue of fundamental rights. We have in all constitutions a catalogue of fundamental rights, sometimes with more, sometimes with not so more types of fundamental rights. But I would like to say that now we have the doctrine says that we have 5 generations of fundamental rights. The first generation is the liberal fundamental rights, civil and political rights. Immediately after the constitutional revolutions, the French Revolution mostly, and we have a second generation of human rights after the welfare state was created, mostly after the Second World War in Europe. Although we can see the first social rights in the Mexican Constitution of 1917, or the Weimar Constitution after the defeat of the German after the First World War, when Germany was a monarchy and changed to a republic. That is the Weimar Constitution that was approved at that time, in 1919. And in those two constitutional texts, we could see the very first formulation of social rights. But if you see any normal constitution around the world, in Europe, Italian constitution, Spain constitution from 1978, or the Italian constitution 1947, or the Grundgesetz 1949, you can see that now we have a second generation of human rights. The rights to public education, public health, public security, public social security, public culture, including. So this is the second generation of human rights. But I said that 5 generations, so 3 generations are missing in this moment. So you have the third generation of human rights, of fundamental rights, that are rights related with the environment, the need to protection the environment from the 60s and the 70s, and the rights related with bioethics laws, the need to protect the human rights dignity against some manipulation of our DNA and some other bad experiences, and some rights related with the informatic and the use of computers, the rights of privacy. Those we can designate, we can put the name of the third generation of human rights. Then we have a fourth generation that are the rights related with minorities, minorities groups, ethnical and religious minorities, or the sexual orientation minorities. Those rights we call the rights of the fourth generation. And now some authors, some professors say that we have in hands the fifth generation of human rights. What are those rights? Perhaps the right to peace, the right to good air, the right to water, because in some countries, in the countries that are not so developed, not developed countries, we can say, we can use this kind of terminology, there is the need to have some basic structures, and also the international organizations, they are recognizing some basic rights, like the right to have water, free water, good water, or air, or right to peace. So this is the fifth generation of human rights. I saw your constitution of Kazakhstan, and it's a very good constitution, and there I can see design and enshrine these different kinds, different generations of human rights: liberal, democratic, social. So I think your constitution, as the Portuguese constitution, is up to date and is in accordance with this new trend of having more and more fundamental rights. I think that is an important conclusion, and it's good for your country, obviously, to have all the rights you have to have, the recognition of those rights in the text, and obviously better if those rights are in life, in your concrete life of the daily life, where we can see the respect from all these different fundamental rights. The next point, the third dimension I would like to underline, is the democracy. This is also a feature of the constitutional state. Obviously, we saw in some other periods of our recent history experiences that were not democratic experiences. I can give different examples. I can give, obviously, the example of my country, because before the revolution of carnations, that was a revolution that changed the legal order and the constitutional order in Portugal. We had an authoritarian, a fascist regime, a totalitarian regime, and because of that we had a revolution made by the military, and now we have a democracy and a new constitution. That's because we had that very good revolution, the Revolution of Carnation, 25 of April of 1974. That is the date, the day of the revolution of Carnations. So, but in terms of political system, what is the meaning of democracy? We can say that we have perhaps three dimensions in democracy. The first dimension is the oldest dimension of democracy. That is the representative democracy. That means that we have a parliament, and the citizens can elect the representatives in their representatives in the parliament. So we have members of parliaments, deputies, that can make laws in the name of the people. That is the traditional system of the representation, political and democratic representation of the people, of the citizens. But we have two more different dimensions of democracy. One is the democracy we can see in referendum. You had recently in Kazakhstan a constitutional referendum. That's a very important thing, because in some issues I think it's better to ask the citizen what the citizens can decide it, in not asking the parties what they are deciding about some important things of people. So in some cases it's better to have referendum than having legislation. Your choice was very good, because the choice of having the people voting the Constitution is a very good thing, and in this case an amendment of the Constitution. We don't have that kind of referendum in Portugal, unfortunately, because I defend the existence of a referendum, of constitutional referendum, but is not allowed in the Portuguese Constitution. But we have referendum, but only for ordinary laws, not about the constitutional amendments or constitutional reforms. But it's a good news for you to have a referendum about constitutional law. But you can also use the referendum to vote ordinary laws. And in Portugal we had we don't have a constitutional referendum, but we can use a referendum to ratify or to approve some ordinary laws. One of them was the issue of abortion, not to have the criminalization of abortion. We had two referendums about that issue. The first issue, the majority of people said no, but after 9 years, a new referendum, the people said yes. So we faced here a different change of the public opinion about that complicated and delicate issue that is the criminalization of abortion. And we also have experienced a referendum about the creation of administrative regions, that is a local governments that now it's their creation depends from a choice taken by a referendum, not directed from the politicians or the members of parliament. And you have also a third dimension, that is the participative democracy. That is, every day we can make democracy. Democracy is not only the day we go to elect our party or our president. Obviously, the day of the election is a very good day, it's a very important day, but we can make every day our democracy. How? Expression our political opinion, expression our political will, gathering people, exhibitions, or creating a new parties or new political associations, and so on. So this is the free exercise of our political rights we have in our constitutional text. That is the democracy of every day. Not a formal democracy, but is very important, this kind of exercise, free exercise of our political opinions, because that means that we have a public opinion. In sometimes public opinion can change a lot the politics and the measures the politicians usually take. Sometimes those measures are changed because of the pressure of the public opinion. With obviously with the importance and the role of the mass media. It is very important to recognize the role of the mass media in this issue of public opinion. So let us go on, and now the next dimension I would like to underline, that is the protection of the Constitution and the role of constitutional courts. I said in the beginning that if we have a constitutional state, we should have separated powers. That's obvious to have a separation of powers, because if the powers are not separated, if the powers are concentrated in a unique person or a unique organ, we can have a dictatorship and we are not having a democracy. The first man that proposed the most interesting theory of separation of power was a French man called Montesquieu. I don't know if you know the name. This man was a judge in the 18th century, the middle of 18th century, published a very important book that is the spirit of law, l'esprit des lois. The Spirit of Law was a very important book because in that book this judge, Montesquieu, proposed a very good theory of separation of powers. So good that when the French Revolution took place, after that all the constitutions in the world, more or less, accept that idea, that theoretical idea of having a separation of the powers between the three powers, executive, legislation and judiciary, and each power is attributed to one organ. So in that situation, if we have a separation of powers, we have more democracy if we don't have that kind of separation. But we can see along the history different interpretations of this principle and the way of putting in practice this kind of principle. But I think now we can accept as a general conclusion after two centuries that the separation of powers is something indispensable to have a good constitutional state. But in that perspective, I would like also to add something else. That is the importance of having a constitutional court. Because the constitutional court is a specialized court that has a specialized function that is supervising if there is any law against the Constitution. And if there is a law against the Constitution, an unconstitutional law, so in that case, Constitutional Court can put down that law and revoke or invalidate that law because the fact that that law is not in accordance, is not respecting the constitutional order, because the constitutional order is in a higher place than ordinary order or the ordinary laws. But now you can ask, but there is the need to have a constitutional court, but we have some other courts that are not constitutional courts. What's the reason of having a specialized court named Constitutional Court? That is a very important question probably you have. Because with this, in that perspective, we have two different models. We have the American model, where there is not a specialized courts leading only with the question of respecting the Constitution, and we have a European model that was created by a very important professor, Hans Kelsen, an Austrian professor, that created the very first constitutional court in the world, that was the Constitutional Court of Austria. In the Constitution, the first Constitution after the First World War, when the empire, the Austro-Hungarian Empire, was collapsed, and then we have many different countries. One of them, a small country, that is Austria. And in the first Constitution of Austria, the first constitution where we can see recognized and created a constitutional court with this kind of specialization in a different way to see and to solve this problem, different from the perspective of the American Constitution. What kind of powers the Constitutional Court can develop and can exercise? We have many different perspectives. We have a preventive judicial review, that is when we have a law that is about to be signed by the President can ask the Constitutional Court if that law is or not is against the Constitution. That is one of the perspectives we can have about judicial review in terms of respecting the Constitution. But we also have another important power, that is after the law is enforced, some people, some public entities can appeal to Constitutional Court in order to the Constitutional Court says if that law is or not against the Constitution. Or we also have the ability in the process in the ordinary court, if the question of having a law that is about to be applied in the case is not respecting the Constitution, in that case the judge or the lawyer can ask the judge to ask the Constitutional Court if that law is against or not against the Constitution. In that case, in your system, the court must suspend the process and ask the Constitutional Court if the law is or not unconstitutional. And after the decision of the Constitutional Court, the ordinary court must take the decision in the sequence of the decision taken by the Constitutional Court. In Portugal, we don't have this kind of power. We have this type of judicial review, yes, but in Portugal, the ordinary court, the first stage court, can at that time decide if the law is or is not against the Constitution. But the lawyer, the parts, can also appeal after the decision of the judge to the Constitutional Court. So in any case, the Constitutional Court will have the final word in each process of deciding if a law is against or not against the Constitution. Obviously, the Constitutional Court can also have some different powers, like supervising the electoral process, the elections, or deciding between conflicts of competence between different public organs. So it's a very important institution, having a good Constitutional Court with good judge, with independent judges, and with dense and very good decisions and good decisions with a lot of doctrine that can be studied, and not decisions that are not taken, or mere formal decisions that where we cannot see the decision about the substance of the process. That is much more important than having any kind of decision where the judge is not deciding the substance of the process. So this is another feature of the constitutional state. Then after this, we have another perspective. I'm terminating my lecture. That is a relationship between state and the religions. As you know, this is nowadays a delicate issue, because we have terrorism, jihadism, terrorism from radicalized interpretations of Islam. Is a very sad thing. You know all the problems about the attempts of terrorism around the world, but we must face this issue in a very delicate situation and perspective, because we must respect all the religions. Even I think it's a good idea that the state having good relationships with the religions, cooperative relationships. So the state must not have an official religion, obviously, because if a state has an official religion, in that case the state is not a secular state. So the state must not have official religion, and must not interfere or define things that are only to be defined by the religion, each one of them itself. But that kind of separation, the idea of secularism, is not in conflict with the idea of having cooperation between the state and the religions. Obviously, if there is a majority religion, the state can cooperate and can have a relationship with all the religions, and obviously more relationships the state will have with the biggest religions we have in each country. You know, Kazakhstan is a Muslim country, I mean, the majority of the population, I think 70%, I suppose. In Portugal, we have a different religion. We are 80% Catholic in Portugal. We also have Muslims. We also have the three families of Islam, Sunnites, Shiites, and Ismailites. We also have Jews. We also have some other denominations of Christianism, Protestants, and Orthodox. Obviously, we are a very free country in terms of recognizing the freedom of religion, but we have a majority of Catholic, 80%. Now, to finish my presentation, and after that I would like to have some questions from you. I would like to talk about this challenge of the future we have just tomorrow. What kind of challenge we have facing our constitutional state and the organization of our constitutional state. I would like to draw your attention to 4 crises. I think we are facing at least 4 crises. I'm an optimist person, but I think we need to face the crisis we have in front of us. One of those crises is the crisis of democracy, because we have political parties, but people nowadays don't recognize the value of political parties, or sometimes the political parties are corrupted. They don't express the interests and the will of the people. Those parties are closed political parties, not open to new generations, new ideas, and so we have, in that dimension, we have a crisis. And there is the need to have different parties to change inside the organization of the political parties and to have more referendums. I think that is the way to solve this crisis of democracy, and to be more attentive to the role of the mass media in order to have a very strong and consolidate public opinion. I think that is the way to solve the crisis of democracy we are facing. Yeah, I'm talking mostly from the perspective of the Western Europe, but I suppose you have the same problem here in your country. The second crisis is the crisis of welfare state, because now welfare state for the Western countries is very expensive for the citizens. We have we pay a lot of taxes, not having the good public services, because the welfare state is not efficient, or are losing the good efficiency that welfare state had before. And now we must face some new experiences and giving some much power to private initiative, economic private initiative, and private sector. So in many countries we have now a trend to privatize some public services, but sometimes the solution is not a good solution. But we must reform the welfare state. At least if you have an old welfare state, that must be changed and change with the new features, because of the new needs of now we have a globalized economy, and when welfare state was founded after the Second World War, at that time we didn't have a globalized economy, and now we have new conditions in the globalized world, and so we need to reform the welfare state. The third crisis is the crisis of the national state. Now our states has no more the same sovereign and the power than before, because all the states now are in the international community with a lot of powers given to the international organizations. And now sometimes we talk about the post-national states or a multicultural states because of migration and because of other things related with this globalized world. And so now we can face some difficulties to have a good state with enough power, but to protect the national people, the national citizens, but at the same time a state that can be in the international scene and to be one of the partners in the international scene in order to have agreements all over the world, just to have the common solutions, mostly in matter of security, international security, because now we have very serious problems about the international security and the international risks we are facing in that field. And that leads me to the fourth crisis, that is the insecure state. There is an author, a German professor, already dead. The name is Ulrich Beck, that was very famous because he invented the concept of risk society. In 2 books he wrote. The first one, Risk Society, Risikogesellschaft, after the Chernobyl disaster in 1986. And after some years later, he wrote another book, Risikoweltgesellschaft. That is the risk society, not now in state, but in international relationship. And I think this professor, Ulrich Beck, and many other professors in the world, they are right when they are saying that we have new risks, new dangers in our international society, and we have to reform our instruments against crime, against violent crime, international crime, international money laundering. It's a very complicated issue. Narco-traffic and traffic of beings, of organs, human beings, and prostitution and so on, and migrations, very delicate and complicated issues. You can see in the Mediterranean Sea, we can we are facing problems, people dying, that come from North Africa to reach Europe. Many people dying in a bad condition when crossing the Mediterranean Sea because they want to have a good life, a better life in Europe, because they don't have that good life in from the national countries where they are, where they belong, obviously, and sometimes they are running out from the wars or from dictatorships. So I think in Europe we must accept these migrants with a good spirit of solidarity, but we also have to be attentive because some rules must be respect about the migration people, the migrants. So it's not easy. Europe is well divided facing the problem of migration because Europe wants a regulated, a ruled migration and not a migration without rules. That is the worst thing for both sides, for the states and for the migrants that want to have a better life in Europe, and I think they have the right to change the future and to seek to have a better future for them and for their families. So this is my reflection today, and now, if you want, I'm available to answer some questions. And Professor Alexei, again, my thanks to this kind invitation, and congratulations. I would like to congratulate you and your class, very attentive and clever class. And it's for me a great pleasure to be for my very first time in this very good university. Thank you for the invitation.